Hey, Brian Bean here with Dream Big Property Management in Riverside, California. We help people just like you become intentional rental property investors. So, pets or no pets? That is an eternal question among rental property investors. But the topic of service and emotional support animals is not up for discussion. It's already been decided. You just have to follow the laws. Can you say no? Can you charge deposits? Can you charge extra rents for them? The short answer is no on all accounts. Under federal and California fair housing laws, emotional support animals and service animals are not pets. They're considered reasonable accommodations for people with disabilities or health issues, which is why even a strict no pets policy is just irrelevant. It doesn't apply. Residents can make accommodation requests for service and emotional support animals, and there is a process in which the property manager or landlord can verify that request. Side note, we're not attorneys. This is not intended as legal advice. Our goal is to raise awareness about important topics in the rental property arena. Please seek guidance from your legal advisor for answers to your specific questions. So, residents asking for a service animal accommodation typically have paperwork from a healthcare provider that informs you that the animal is necessary for someone with a disability. This is not a license for you to get into their health issues. You can't start asking them about their specific afflictions or conditions, and rightfully so, by the way. You wouldn't like having to answer private questions like that either. But this does make the process easier. You're not able to, and therefore required to, make judgments about the severity of a need or just how badly someone needs assistance. That's outside of our and your expertise. You must leave that to the medical professionals. And that's what the accommodation request letter is for, by the way. Also, reasonable accommodation doesn't cover just any animal. If the specific animal poses a direct threat to health or safety, or it might cause substantial property damage, you may be able to deny the request. I'm not talking about breed restrictions. Pit bull terriers and German shepherds can be service animals. Emotional support crocodiles? Probably not. But either way, talk to an attorney before you render any such decisions. Residents are responsible for any damage caused by a service or an emotional support animal, just like any other occupant of a property. You can't charge an extra deposit up front for that occupant, but you may be able to charge a departing resident for repairs. Again, check with your attorney for specific situations. Bottom line, ESAs and service animals are not pets. You must allow them as a reasonable accommodation. You can't charge pet fees. You can't require pet deposits, but you can verify the accommodation request and you can hold residents responsible for damage. Have questions about emotional support animals or anything related to the right and profitable way to run your rental property? Call me today, 951-314-5402. Happy to share. You can also find valuable information on our website, dreambigpm.com. And if you found this useful, we have more. Check it out. Punch that subscribe button. It helps others find us, and we'll alert you when episodes are posted. Don't be accidental about your future. Be intentional to your success.